Court will note that this matter is before the court today for the ruling stemming from the trial which took place on January 5th, 2024, which was concluded on that date as well. I would first let the parties know in this case that both of your attorneys did an excellent job in representing you, and they basically presented the case as in a very good fashion, and based upon what was presented, the court does note that they did present what the court was needed for purposes of deciding this particular matter. First, the court will find that the testimony did establish the statutory basis. There had been a showing there had been a breakdown of the marital relationship, so the court will grant the divorce in this case. Court will note that credibility is always a consideration in every case. Oftentimes, a party will allege that the other party or one of their witnesses was not truthful or was lying, and the court has found that inconsistencies in testimony do not always mean that an individual had lied. Conflicting testimony can occur as a result of a witness's background, perception, bias, understanding, misunderstanding, or simply mistake. When inconsistencies occur, the court will attempt to determine if they can be reconciled with other testimony or evidence. There was some conflicting testimony in this case, but not more than what the court would normally see. The court will assess the credibility of the witnesses and evidence that was presented in this particular case. Court will note that much of the testimony the court heard was self-serving without corroboration, and this makes the court's job much more difficult in making a ruling. Court will note that the parties were married on December 11, 2004, that the action was filed on January 30, 2023. There was a proof of service of this action on 4/7/23, and a default having been entered on 5/24/2023. Defendant's attorney filed a motion to set aside the default and an appearance on August 23, 2023. Then the motion hearing was held on August 28, 2023. The court entered an order subsequent to this on September 6, 2023, which sent the case to mediation and held that defendant's motion was in abeyance pending mediation. The defendant's motion to set aside the default was not filed for over 4 months after service in this particular case. The default was properly entered pursuant to MCR 2.603. Subsection D of this court rule provides that court can set aside a default upon a showing of good cause. Defendant has alleged that the good cause that existed because the parties were negotiating a resolution of the disputed matters after the default was entered. The court does not find this to amount to good cause sufficient to set aside the default. Defendant has asserted a claim for spousal support, and I state that there, as I stated previously, there are consequences to a default. Due to the default having been entered and the court finding that good cause to set aside the default does not exist, the court finds that defendant's claim for spousal support is extinguished and foreclosed by the default. Aside from the default, the court will state that I was not convinced that defendant has a claim for spousal support pursuant to Michigan Compiled Laws 552.23 and the factors identified in Sparks v. Sparks at 440 Mich 141, a 1992 case. The matter really is before the court for custody, parenting time, and support. The court will note the parties have 3 minor children, Delaney 16, Sadie 15, and Clyde 13. Custody is governed by the Child Custody Act, MCL 722.21 et sec. Pursuant to Michigan Compiled Law 722.26a, Parents shall be advised of joint custody, and the court shall consider an award of joint custody. The court shall consider whether joint custody is in the best interest of the children pursuant to MCL 722.23, which we will examine in a moment. And subsection B, whether the parties will be able to cooperate and generally agree upon important decisions affecting the welfare of the child. However, the first task that the court has in any case is to determine whether an established custodial environment exists. An established custodial environment exists if over an appreciable time, the children naturally look to the custodian in that environment for guidance, discipline, necessities of life, and parental comfort. The statute provides that the age of the child, the physical environment, and the inclination of the custodian and the child as to the permanency of the relationship shall be considered. In this case, so the first task is for the court to consider that particular matter. The plaintiff testified that defendant had little contact since the separation of the parties, which occurred on or about November 18, 2022. Plaintiff also testified that she has a close relationship and that she does not believe that there is much bonding between defendant and the children. Plaintiff stated that both of the parties cared for the children when they were married, although she was principally responsible for much of the care. She testified that prior to separation, defendant was involved, however, that weaned after separation and that his contact was minimal. The defendant will acknowledge and did through his testimony that in this particular case, that in the time since the separation, he'd not had Delaney in his care on an overnight basis for any overnights. He'd had Sadie in his care about 4 overnights and Robbie 12 overnights since, again, the separation in November of 2022. Defendant testified that my wife is good at reading the children and Delaney opens up to her mother, end quote. He testified he does provide guidance, but not assist in school activities recently. James Nelson testified defendant was a good relationship with his kids. Amy Nelson testified defendant was attentive to his kids. Bill DeSmit testified that defendant and children had a positive relationship, and Michelle DeSmit testified that defendant was a good father. When we look at the evidence as a whole, and we look at the fact that since separation, the defendant has had minimal of any overnight contact, notwithstanding the court does note he testified that he does pick up the children, runs them to various places. He has had contact on a weekly basis. It does appear in this matter that, and this court is clearly convinced that the children look for guidance, discipline, and necessities of life, and they look to the plaintiff mother. The court will therefore find that the established custodial environment is with the plaintiff. This is important because once the established custodial environment is established, it cannot be changed without there being presented clear and convincing evidence. Clear and convincing evidence is evidence in which would produce in the mind of the trier of fact a firm belief or conviction as to the truth of the allegation sought to be established. Evidence so clear, direct, and weighty and convincing as to enable the fact finder to come to a clear conviction without hesitancy of the truth of the precise facts in issue. So the court will examine the factors under the best interest of the child test as delineated under MCL 722.23. Court would note that there was minimal testimony concerning many of the factors that the court has to consider, but I will consider them based upon the evidence presented. The first factor is the love, affection, other emotional ties existing between the parties involved and the children. In this case, the plaintiff testified, and some of this is reiterating under the established custodial environment, but I will as it relates to each of the factors to establish the basis for the court's determination. Plaintiff testified she has a close relationship with the children and they are together every day. She has a loving, affectionate relationship with them. She does not, however, believe that the defendant is bonded as much to the children. She testified that the defendant curses at the children and has had little contact since separation, which again, he acknowledged. However, James Nelson testified that the defendant had a good relationship with the kids. Bill DeSmit testified that the kids had a positive relationship with defendant. Court will note that the party's adult child, Aiden, testified about his relationship with the defendant, and he talked about a strained relationship between the defendant and the other children, but he did acknowledge that he had not observed his siblings and the defendant together since approximately December 2022, so well over a year. When the court looks at this factor, the court will find that looking at this love, affection, emotional ties existing between the parties, that the plaintiff mother has a slight advantage on this factor. Next factor is the capacity and disposition of the parties involved to give the children love, affection, guidance, continuation, the education, and raising the children in a particular religion or creed. There's two factors, the capacity and the disposition. The capacity, as the parties already shown, they have the capacity to do that and have done that. The question is, do they have the disposition as well? Court does believe that the parties both have the ability, capacity, disposition to provide love, affection, and guidance. As it relates to the continuation and the education, the plaintiff testified that she is the one that does the homework with the children, although the defendant had in the past. The defendant had used to go to conferences, but hasn't in the last year or two. Plaintiff testified she goes to all the schools, the children's activities at school, and that the defendant has went to a few. Plaintiff testified that she was the one that provided for and paid for these educational trips for the children, and defendant confirmed that he did not attend some of the children's school activities. He testified that he did not assist with school activities recently. Neither party was involved in a religious upbringing of the children on a regular, consistent basis, so the court is not considering that. However, when again consider the continuation in the education and raising of the children, it does appear that the plaintiff mother does have a slight advantage. Factor C is the capacity and disposition of the parties involved to provide the children with food, clothing, medical care, and other remedial care recognized or permitted under the law in place of medical care and other material needs. Both parties have provided material needs for the children. Court will note that the defendant had voluntarily paid the sum of $1,000 per month during the pendency of the case until September 2023. This did provide the plaintiff the ability to provide material needs for the children. Both parties have income which allows them to provide for the material needs of the children. The court has to look at, and I will look at as far as the medical needs of the children. Plaintiff carries health insurance for the children at a cost of $300 per month. She testified she was one that made the medical appointments. However, in the past when they were together, the defendant may have scheduled some of those. She is the one that takes the children to the medical appointments, although in the past, the defendant had helped. When I balance these, it does appear that the plaintiff was more involved in providing for the medical care of the children, which would give her a slight advantage on this factor. Next factor is the length of time the children have lived in a stable, satisfactory environment, the desirability of maintaining continuity. The plaintiff has remained in the marital home with the intention to remain. Defendant has not disputed that this home is a satisfactory environment for the children. Defendant testified he lives in a one-bedroom apartment which hinders his ability to have the children on an overnight basis. Defendant testified that his girlfriend lives with him, and he has testified that, again, this arrangement with the apartment is not the best accommodation and not the ideal situation. He stated that once the plaintiff refinances the house, he will be in the ability to purchase another place, which will be more accommodating to the children. The court, however, has to assess the evidence as it currently exists and not speculate as to what will happen in the future, whether it's a matter of months or years. In view of that, the court will find that this factor does favor the plaintiff mother. The next factor is the permanency of the family unit of the existing or proposed custodial home or homes. Both parties have resided with a significant other, and neither party has plans to change this. The court therefore finds that this factor is equal as to both parties. Next factor is the moral fitness of the parties involved. The testimony is alleged by plaintiff that defendant has a drinking problem. There has been testimony by both parties about this. Also, testimony by James Nelson about an altercation that occurred at a restaurant where a defendant was drinking while Aiden was in his care. Amy Nelson also testified about this event and defendant's intoxication. Plaintiff testified that defendant went through AA sometime in 2022, and Aiden testified about the defendant's drinking problem as well. The defendant testified about plaintiff's affair, which plaintiff admitted, and she testified that defendant was aware of this and encouraged this, although there is absolutely no corroboration of this fact through the testimony. And unfortunately, the court notes that both of the parties have involved the children in these adult issues to the detriment of the children. The court will therefore find that this factor does not favor either party in this case. Next factor is the mental and physical health of the parties. There was very little evidence concerning this. However, that plaintiff did testify that neither party had any physical limitations, and there was no testimony about mental disabilities or infirmities that would impact this. The court will find that this factor does not weigh in favor of either party. The next factor is the home, school, and community record of the children. Both parties have testified about the children doing well in school. It would appear that plaintiff was the one that assisted the children with schooling, extracurricular activity, sports, dance lessons. The defendant testified that he did not assist in school activities recently. There's no testimony about community record of the children. The court will find that this factor did slightly favor plaintiff mother. Next factor is the reasonable preference of the children. If the court considers the children be of sufficient age to express a preference, clearly the children are of sufficient age to express a preference. They did, and the court is taking that into consideration in this matter. Next factor is the willingness and ability of each of the parents to facilitate and encourage a close and continued parent-child relationship between the children and the other parent. In this matter, plaintiff testified that she has encouraged the children to go with the defendant, and she has not kept them from him. Defendant testified that he did involve discussions, or the children in discussions of the plaintiff's affair. And as he stated, I quote, "My emotions got the best of me," end quote. He also, the court will note that he'd involved the children in adult matters, and I find that this can only be damaging to the relationship between the children and the other party. And other than this issue, the parties have been civil and cooperative with each other concerning parenting time. Defendant acknowledged that he has not forced the issue of parenting time and testified he has in an attempt to accommodate the children desires in this matter. Court believes that each of the parties will facilitate and encourage a relationship between the other party and the other than the children. So the court has weighed this factor equally in this matter. Next factor is domestic violence, whether the violence was directed against or witnessed by the children. There's been no testimony about domestic violence. The court will therefore not consider this factor. Next factor is whether any other factor considered by the court to be relevant to the particular child custody dispute. Court will note that Aiden, the adult son of the parties, did testify, and the court is considering his testimony concerning how the parties treated him as well as his observations. The court will note that in the case of In Re Taurus X, that the court can note that how parties do treat one child is indicative of how they may treat the other children as well. When the court considers all the evidence in this case and all the factors under the best interest of the child test, the court is clearly convinced that it is in the best interest of the minor children to remain in the physical custody of the plaintiff mother. The court does believe in this matter that the parties can communicate and can discuss and agree upon important decisions concerning the children. As a result, the court will grant the parties joint legal custody. The next factor that the court has to consider then is parenting time. Parenting time is governed by Michigan Bylaw 722.27A. And again, the factors set forth concerning that. The court will consider the best interest factors as I have. The court will also consider the following factors: special circumstances or needs of the children. There are none in this case. Next, whether the children are less than 1 year of age, they are not. Next, likelihood of abuse or neglect of a child during parenting time. The court does not believe that based upon the evidence that, again, there is a likelihood of abuse or neglect. The next is the likelihood of abuse of a parent during the exercise of parenting time. The court does not believe that there's been testimony or evidence of that. Next factor is inconvenience or burdensome impact of travel. The parties live relatively close to each other, so that is not an issue. Next factor is whether the parent is reasonably expected to exercise ordered parenting time. The court does believe that, notwithstanding the fact that the defendant has not taken much in the way of parenting time, that he would, again, under various circumstances, take the children as ordered, and that he has done it through the week, although it's not been ordered in this matter. Next factor is whether parents frequently fail to exercise parenting time. Court will only note in that regard that the parenting time has been offered to the defendant. He's not exercised that, somewhat because of his limited situation with his home and the inability to have the children on an overnight basis. Next factor is threatened or actual detention of the children. There's been no evidence of this, so the court will not consider that. Next is any other factors to be considered. When the court considers this particular factor, the court does believe that the parties have been cooperative, and the court would hope that this continued. The court will therefore grant to the defendant standard parenting time, alternating weekends from Friday 6 o'clock p.m. to Sunday at 6 o'clock p.m., midweek from 4 to 8 o'clock p.m. on a Wednesday in the event that the parties cannot agree to another time, alternating holidays, defendant to have spring break in each year, and to alternate weeks in the summer. However, the court notes that that's not very capable of having that at this time. The court will order that this parenting time will occur at such time as he has adequate accommodations for the children to have bedrooms in his home. Until then, the parties will mutually agree upon any overnight parenting time as they have in the past. Court next have to consider child support. As the plaintiff testified, the parties had a lavish lifestyle when they were together. They took trips and they ate out most evenings. The parties were able to maintain this lifestyle on two incomes. Not just two incomes, but the parties owned approximately 5 rental properties, which generated income as well. The rental income is reflected in the parties' 2021 and 2022 joint tax returns admitted as Defendants Exhibit A and B. Plaintiff has an income of $84,000 a year with a deduction of $300 per month for health insurance attributable to the children. There was testimony about the plaintiff had income from reselling some various event tickets. However, this appears to be an isolated circumstance and has not occurred on a regular basis, so the court will not consider that. The court will note that the defendant's income is much more difficult to assess. Plaintiff has alleged that defendant has much larger income than appears in the parties' tax returns. Plaintiff submitted an exhibit, the bank statements of the parties' joint account as well as the defendant's business account. The business account statements evidence a substantial amount of money going through the account. Defendant testified that he liked to deal in cash. It would move cash from the accounts and then redeposit it at a later point when if it was not needed or needed in the account. Defendant testified that he has substantial business expenses, labor, materials, equipment, as well as assorted other business expenses, and many of these are reflected on the joint tax returns of the parties. Defendant's Exhibit A, the parties' joint 2021 tax return reflects plaintiff's income and rental income from Kate's Diner, capital gains income, and various deductions and expenses for C Squared LLC. The parties testified, or there was included in the tax returns or Schedule C, the profit and loss from the business, which show a profit in 2021 of $8,222. However, the court does note that there are other expenses that could be added back. There were vehicle expenses of just over $18,000 and depreciation of $1,371. If the court adds those back, the income would be $27,737. Court will note that these can be added back in pursuant to the Child Support Formula Manual, Section 2.01, parens E, parens 4. Defendant's Exhibit B, the Schedule C for a profit and loss for the C Squared Construction LLC showed a business profit of $21,565, a vehicle expense of just over $25,000, and depreciation of just over $1,000, bringing the total, if I added that back into, about $48,000. The defendant testified that his net income is between $22,000 and $30,000 per year. The plaintiff testified that she had to borrow money to support herself during the time the parties had separated. Defendant testified that, as reflected in Plaintiff's Exhibit 7, that he borrowed $25,000 on April 19, 2023 from Best Egg and $15,725 from Lending Point on April 20, 2023 for a total borrowing amount of $40,725. The parties had both previously testified as well that when they sold Kate's Diner, they paid off $60,000 in credit card debt. If the defendant was making the amount of money claimed by plaintiff, then the question would be, why did he have to borrow over $40,000 in April of 2023? And why did the parties have over $60,000 in credit card debt? When the court calculates the plaintiff's income and averages out consistent with the 3-year comparison contained in the tax returns, the court does believe that the defendant's average income would be approximately $38,000 when those various expenses are added back in. Again, plaintiff challenges the defendant's income. However, the parties did file joint tax returns, and when they signed those returns, they did so with the following statement, and I quote, "Under the penalty of perjury, I declare that I have examined this return and accompanying schedules and statements, and to the best of my knowledge and belief is true, correct, and complete," end quote. Plaintiff admits that she signed the tax returns for each of these years after she had scanned through them. She cannot now claim ignorance when it is self-serving to do so. The court therefore will find that, again, the amount of his income is in the amount of $38,000 for purpose of calculating the child support. Court will therefore take those two amounts and her income of $84,000 with the deduction of $300 per month for the health insurance attributable to the minor children for calculations of child support. With that, I think the court has addressed all the issues that need to be addressed. Ms. Greenlee-Clore, has the court failed to address anything or missed anything before we conclude?
Your Honor, I think because there is a PPO between the parties, I think we'd requested that the parties communicate via an app. Can the court make a ruling on that?
Okay. Let me address Mr. Schaefer. Do you have any problem with the parties communicating through our Family Wizard or Parent Talk or any of the other various apps?
Well, I usually would not if, in fact, I thought there was an ongoing problem with that. But I would hope that these people can talk to each other because they have joint custody for the benefit of the children, and Wizard and whatever other app always, in my estimation, hampers that ability.
Okay. What the court will do at this point, Ms. Greenlee-Clore, is the court will make an exception on the PPO to state that the parties can communicate concerning specific child-related matters and court-ordered parenting time. So in this particular matter, the court will tell both of the parties, do not, in fact, communicate with the other party under the guise or ruse of child-related matters. I've had in the past where parties will say, well, I wanted to check and see if the children are able to come this weekend, and then they engage in a diatribe about all of the problems they've had during the marriage or issues that they take against the other party. Again, that will be a violation of the PPO. It's only as it relates to specific child-related matters and court-ordered parenting time. Anything else, Ms. Greenlee-Clore?
No, Your Honor.
Mr. Schaefer, is there anything you believe that the court has failed to address or needs to address before we conclude?
No, I think you've covered, Your Honor.
Okay, I'll ask Ms. Greenlee-Clore, as you represent the plaintiff, that you would prepare the appropriate paperwork and pleadings in this matter, submit those to the defendant court for approval, and submit those to Mr. Schaefer as well to see that it is consistent with this court ruling. With that, the court will end this matter at 4:33 p.m. You're free to go. Good luck to both of you. I hope you have that everything works out and that you have a wonderful day.
Thank you, Your Honor.
Thank you.